Mr. Lucas doesn't need an intro, but he needs an intro. So let's see. Lucas has been in the surveying business since 1976. He is a licensed surveyor registered in Alabama, Florida, Georgia, Mississippi, and Tennessee. Lucas is a licensed attorney and was admitted to the Alabama State Bar in 2003. He specializes in land boundary issues as an attorney, a land surveyor, a consultant, a mediator, and expert witness. He is a seminar leader on surveying topics, which is why we have him tonight as well, including boundary law, the law of easements, water boundaries, surveying evidence and procedures, expert witness testimony, business law, contract law, torts and liability. He has over 30 titles developed in his seminar library, and has also authored Alabama Boundary Law and the Pincushion Effect, which, let's see, Mr. Lucas did that on week 58 for us. And he also did week 63, we did contracts as well. So this is the third time we've had Jeff, which I appreciate your time. And so, as always, thank you for taking the time jumping on tonight and the past few times, but we appreciate all your knowledge on both surveying as an attorney and as a surveyor. So this is always a fun topic that we've talked about a few times at seminars and that kind of stuff. So I appreciate it as always, Jeff.
Well, thanks, Trent. I appreciate it. And I appreciate being your guest here tonight. This land surveyor's equity judge, the material I sent you was a chopped down version of that. I basically just have my 10, what I call 10 commandments on here. But it's just a conversation. Those are just conversation starters. And I did rearrange it a little bit because usually at the end I go into all of our surveying forefathers, a lot of our surveying forefathers who talk about the surveyor's role as a judge. So, and I think we're all interested in, all surveyors have some sort of interest in Cooley's paper, the quasi-judicial function of the land surveyor. And actually, he gave that first paper in 1881. I'm going by memory here. I covered it in my Cooley series in my newsletter. So he was at the Michigan Engineer and Surveying Land Surveying Conference, and back in those days, you know, they didn't do seminars. People would practitioners would write a paper, and then they would present their paper. So Cooley wrote a paper. They invited him to come to the conference and present his paper, and his paper was the quasi-judicial function of the land surveyor. And I think, I don't know for sure, but I think everybody's jaws dropped when he was given the paper, because there was a lot of conversation about about Justice Cooley's paper. And he was in, they had conferences back in those days. Illinois had a similar setup. They would have conferences every couple of years. And so they invited him back in 1883, and he couldn't make it, but he sent his paper again with some edits, not edits, but he added some more information in that 1883 paper. But he's probably best known for the 1881 paper, which was published in their proceedings, and that's, I think, where most copies of his paper come from. And you can find that online if you search for it. You can find it, just I would search like the Michigan Engineer and Land Surveyors Conference 1881, and you'll probably find it. So I think we've all, as surveyors, have been fascinated to a certain extent about that paper and Cooley's description of the function of the land surveyor. But he wasn't the only one. And one of the things that's never distinguished in all of these discussions is what kind of judge are we talking about? And that's where we need to understand the difference between law judges and equity judges, and understand the difference between law and equity. Now, I've often said on many occasions that at our core issue, what we do as land surveyors, at our core issue, we have more in common with the legal profession than we do with the engineering profession, because surveying is not an engineering project. It is an evidentiary exercise. And while we can't be judicial officers in today's environment, or back in Cooley's day, that, in my opinion, is a direction we should be looking at, sort of not paralegals, but being able to do, as land surveyors, being able to do what is traditionally considered to be practice of the law. I mean, there are several little areas we could we could expand into if we didn't hit the buzzsaw of the attorney lobby, such as preparing deeds. In most jurisdictions, that is considered practice of the law. I know here in Alabama, they definitely consider the preparation of deeds and other legal documents the practice of the law. But you know, when I was in law school, I spent 2 semesters in property. One was personal property one semester, and then real property the second semester. And you know, we never even saw a deed. You know, we never even saw it. The only reason I knew what a deed looked like was from my surveying experience. And then, of course, if you pass the bar, which somehow I did, now I'm an expert on deeds, and I've never even seen one. You know, so it's not rocket science, and it could come in handy in our practice, especially in this role of this quasi-judicial role that we do have. And we'll get into some of that here in just a minute. But you know, we do, in fact, surveyors do, in fact, produce some very legal documents, like a subdivision plat, for instance. That's about as legal as it gets. You're actually creating new property that's going on the ground, and so that's a legal document. Preparing deeds isn't rocket science. Preparing contracts isn't rocket science, and those are 2 areas of the law that I think I'm not the czar of surveying, but if we were looking for ways to expand our practice rather than contract our practice, as we've had a tendency to do over the decades and centuries, that would be an area of the law that would be just suited for the land surveyor, and especially like mediation and boundary dispute resolution, boundary line agreements. You know, those are contracts, and a lot of, it's not universal, but in many jurisdictions, the State Bar Association is going to see the preparation of contracts as the practice of the law. Of course, you can prepare your own contract. You can prepare your own deed for your own purposes, but when you start stepping over the line is when you start doing it for others in a representative fashion and being paid for it, and that's kind of where you cross the line there. But so I've read, and we'll get to them in a minute, some of them here in a minute. I've read a lot about what some of our surveying forefathers thought about our practice, and there's many articulations of this idea that we are some type of a judge. We have a quasi-judicial function as a judge, but nobody ever makes the distinction of what kind of judge. We certainly can't be law judges. Law judges dispense the law, and those judges, our court system in the United States, those judges are basically your lower tier courts, like your traffic courts and your municipal courts and the lower tiered courts, and everybody's court system is set up a little different. And some of these courts are called district courts, some of them are called circuit courts. So there's no one size fits all. But for instance, in my state of Alabama, we have, of course, our Supreme Court, and then that's the highest appellate court in the state. And then we have our courts of appeal. That's the second tier of appellate courts. And below that, before you go up on appeal, our highest courts in our state are called circuit courts. And they have both law and equity jurisdiction. The lower courts below that, the district courts, criminal courts, municipal courts, traffic courts, they don't have equity jurisdiction. And so what is equity? What is equity? Well, equity is what is good and what is fair. That's what equity is. And it came out of England, and my history might be off just a little bit here, but there was the King's Bench, and the King's Bench was the law courts. And so whatever the king decreed, they wrote it down in the books, and that was the law. But over time, the law just wasn't sufficient to take care of all of the transactions people were having, in society. And so as the population of England grew, and there was private property rights, and there were other controversies that the law didn't have an answer for. And so finally, I think it was King James II. It developed over like 300 or 400 years. Finally, King James II told his Secretary of State, which was at that time, it would have been the Archbishop of Canterbury, you need to set up a new court. You need to set up a court where you can listen to these other controversies that the law didn't have an answer for, and those were the equity courts. And today in the United States of America, we still recognize that to a certain extent. They might be called your chancery courts. In Tennessee, they're called the chancery courts. In my state, they're called probate courts. Those aren't law courts. Those are pure equity courts. And so, for instance, a probate judge in the state of Alabama doesn't even have to be an attorney, because they're not dealing with the law. Or if they are dealing with the law, they're dealing with a very small aspect of the law. So the law, equity is not the law, and the law is not necessarily equitable. And in the United States, so they had two separate courts there. Well, probably others, but the two primary courts in England, which we adopted the English common law as the United States, and most states adopted the English common law. There were two separate courts. There were the law courts and there were the equity courts. And equity could not dispense the law. And the law courts couldn't dispense equity. So there were two separate courts, but in the United States of America, and especially at the federal level, we never had two separate courts, two separate law courts, and two separate and then a separate law court and a second or separate equity court. But the jurisdiction survived. And so our higher tier courts, certainly our Supreme Court, has dual jurisdiction. They have law jurisdiction and they have equity jurisdiction. They can dispense the law and they can also dispense equity. So one of the things that these gentlemen of the past, when they start talking about the surveyor's function as a judge, they never make that distinction. Not a law judge, but more like an equity judge, because we can't dispense the law. We are supposed to know the law. We've got to know the law. We've got everyone's charged with knowing the law. Ignorante juris non excusat. Ignorance of the law is an excuse for no one. So we're all charged. All citizens in the United States of America are charged with knowing and applying the law. And that's been another frustrating aspect of being a surveyor and have been around so long. You know, when I was when I was coming up as a surveyor down in Florida, and through the apprenticeship, method, I was told, and I got licensed. I read all the books you're supposed to read, and I passed the exam. And but still, my mentors were telling me, we don't know the law. We don't know the law. We can't apply the law. All we can deal with are the facts. Now, there's a ring of truth to that, but as a citizen of the United States of America, I have to know the law. I have to know what the law is. I'm charged with knowing what all the law is, and not only knowing what the law is, applying the law. But the distinction between equity and law also tells us something about surveying. And I've heard this a lot, especially since I became a seminar speaker, is we're not supposed to know the law. And what you're talking about, Jeff, is practicing the law. And that's the furthest thing from the truth, because what we really are seeing correctly is closer to equity judges, not law judges, but equity judges, dispensing what is right and what is fair. That's what equity is. So with that, move forward a little bit, and I'm not your attorney. So I'm not here to tell you what the law is. I'm just here to give you some information that you might want to use in your daily practice. So Cooley, the judicial function of the surveyor, it wasn't even called the quasi-judicial function. The title to the paper was the judicial functions of the surveyor. And it was reprinted from the, I reprinted it from the old Surveying and Mapping magazine. Surveyors cannot, so let's make it clear at the beginning. I'm not saying that we're judicial officers. Surveyors are not and cannot be judicial officers. And this is a quote from Cooley out of that paper. But in a great many cases, they act in a quasi-judicial capacity with the acquiescence of the parties concerned. And it is important for them to know by what rules they are to be guided in discharge of their judicial functions. So the rules are, what is the law? And then taking factual, this is what an equity judge would do. They know what the law is, but then they're going to get a factual situation that comes in before them, and then they've got to dispense equity. And in some cases, there's a little bit of law that gets thrown in there too. But that's their primary function. Pure equity judges is to hear controversies and then dispense equity. But actually, if you think about it, and I've done a lot of thinking about this, the closest description of the function of the retracement surveyor is actually that of a jury sitting in a law court. The jury sitting in a law court they will be called the triers of the facts. Now, if you don't have a jury, the judge is the trier of the facts. And boundary dispute cases have to happen in these dual jurisdiction courts. You can't solve a boundary dispute in a law court for the simple fact that there's no law that's taking place. There's no law that's taking place. There's only one legal argument in all of boundary disputes, and that's when you're trying to determine an adverse possession case, because then you have a fight over the title to the property. What is the title to the property? And so when you have a legal fight when you have an adverse possession case on your hands, you got a legal fight. All of the other boundary location doctrines don't affect the title. And this is something that's really, really difficult. It took me a long time. I'm post law school. It took me a long time to wrap my brain around this idea that the title documents, there's a difference between the title there will always be a difference between the title to the property and where it is actually factually located on the ground. And that's a hard thing for a lot of people to wrap their brain around. That's a hard thing for a lot of judges to wrap their brain around. That's a hard thing for a lot of title attorneys to wrap their brain around. We'll get into a little bit more of that, but I brought this was my commandment 10, but I kind of brought it to the forefront so you can see what I'm talking about relative to what our surveying forefathers thought about what we were doing as surveyors. So there's a picture of Cooley, actually considered to be one of the greatest legal minds this country has ever produced. He single-handedly wrote the Federal Railroad Code at one point in time in his career. The law school at University of Michigan is named after him, the Cooley School of Law in Ann Arbor. He was born in 1824, died in 1898. Not too long after he he had several cases. Deal versus Zanger is one of the most, I think, outstanding ones involving boundary disputes and surveyors, and telling the surveyors what their function should be, especially Deal versus Zanger. The city surveyor has completely lost sight of where his attention should have been focused. It's not how a completely precise survey would locate the boundaries. It's how the original states located the boundaries. And that goes to the core of the doctrine of monuments. And what is the foundation of the doctrine of monuments? The foundation, the reason the monuments are so important is because the property rights attached to those monuments that are on the ground. When they move into when they buy the property, they move into the property, they glom onto those sticks that are in the ground. And when reliance sets in, then the property rights attached to those sticks. And that's why there's a difference between the location of property out on the ground, the physical factual question of location, and what was put on a piece of paper, trying to represent where the boundary lines, the property lines are actually located on the ground. And that was another no-no. Don't ever talk about property. Don't ever talk about property boundaries. And it's still in evidence and procedures on page 2. Surveyors locate deeds, deed lines. They cannot and should not locate property. They cannot locate property rights. But in the final analysis, I'm sure all of you guys realize this. I'm sure you've gone through enough material where you've come to the realization that once you perform correctly a retracement survey, you have done nothing less than identify the limits of that ownership on the ground. It's as a result thereof. You've done nothing less than locate on the ground the property rights. That's what you've actually done. You will still see an article every now and then about how surveyors can't locate property rights. They can't tell people what they own. They can't, all of this nonsense. And it's to a certain extent, it's a little bit maddening that people still think, even surveyors who should know better, still think that by performing a correct retracement survey and it doesn't match up with the title documents, then you're practicing the law somehow. And that's absolutely the reverse of what happens when you go to court. When you go to court and there's a difference between the title documents and where the property is actually located on the ground, where the property rights exist on the ground, it's the title documents that must conform to what's on the ground. You don't make what's on the ground conform to the title documents, which is the absolute foundation of the Pincushion form. It's the surveyor's solution. It's the surveyor's solution to the dilemma. It is a dilemma. I'll admit it, it is a dilemma. It's hard to wrap your brain around the idea. What, the title documents don't match what's on the ground? And so when they don't, what the surveyor does is the surveyor goes out and makes sure that the title documents are on the ground. If it's supposed to be 100 feet wide, it's going to be 100.00 feet wide. If it's supposed to be 150 feet deep, when that surveyor leaves the field, it's going to be 150.00 feet deep, even though there's other monuments in the ground. That's the Pincushion point. The collective confusion, the land surveying profession's collective confusion over our duties and responsibilities toward property boundaries. That's my definition of the Pincushion corner. And that's a problem. That's a problem. And I'm often Pincushion corner now. And I shouldn't really even be there. But that's a problem. That's a problem because that shows the public, the landowning public, people who should matter, that we don't know what we're doing. What if there's only one corner in legal contemplation? How is it then that we have multiple monuments all representing this one corner? And if the fundamental principles of surveying are, you're either an original surveyor laying out new property lines for the very first time, and you can't be an original surveyor unless you have a common grantor. You got to be working for a common grantor. You're creating new property lines. That is a measurement and math task. Then everybody will say it. You say, so what's the second role of the surveyor? And everybody in the audience says to follow in the footsteps of the original surveyor, not to correct them. Not to correct them. Yet, we're still driving monuments in the ground when there's already perfectly good monuments already representing the true and correct corners of the property. So that's a problem for us. Now, the title attorneys are no better. They're no better than the land surveyors on this issue. If anybody's doing Alta surveys these days, they know this for a fact. Because if you bring your survey back, you found the monuments, you surveyed the monuments, you have identified the location of the property on the ground, but your measurements don't match what's in the deed. So what do the title attorneys want you to do? Rewrite the legal description so that they can fix the title. There's nothing wrong with the title. There's nothing wrong with the title. So, but here's the difference. Surveyors monument their confusion for the whole world to see. And what the title attorneys do when they have the surveyor rewrite this legal description, then they go out and do a bunch of quitclaim deeds. You know, everybody's going to quitclaim to this new surveyed line. And then they're going to go file all those quitclaim deeds in the courthouse where nobody's going to see them. And even if somebody sees them, they don't know what the hell the attorneys are doing. Well, there must be fixing something here. They're worse than the Pincushion surveyors. They don't know the difference between title to property and the location of that property on the ground. So this is not practicing the law, it's actually practicing surveying. The law is the law and equity is equity, not the law. Blacks defines equity as justice administered according to fairness as contrasted with the strictly formulated rules of the common law. Equity isn't the law. It's not statutorily driven. The only way you can find out what the maxims of equity are is you've got to study court cases. You got to read enough court cases to see when they're dispensing equity, what are the foundational principles that they're working off of. And so they have been, I got this actually out of my second semester property law book. It might have been property law or it could have been remedies. I don't remember, but the author came up with some nice handy dandy, a dozen maxims of equity. There are others out there. One who seeks equity must do equity. One who comes into equity must come in with clean hands. That's commonly referred to as the clean hands doctrine. Equity aids the vigilant, not those who slumber on their rights. Here's an equitable principle underlying things like our recording statutes, okay? Equity aids the vigilant. You sleep on your rights, you're going to lose them. That's an equitable principle. There's an equitable principle for why we have things like adverse possession. I know adverse possession came from, most commonly referred to as coming from like Roman law or something like that, but here's an equitable foundation for it right there. Equity delights to do justice and not by halves. Equity regards as done that which ought to be done. Equity regards substance rather than form. This is where I get my daughter. Okay, I say, sweetheart, this is not equitable. You aren't acting with equity here. She is form over function. Okay, this is function over form. She is all form over function. She has a beer drinking husband. She has 2 muddy dogs and 3 snotty-nosed kids, and she insists upon having white furniture. No, no, that's putting form over function. That is not equitable. That is not equitable. Between equal equities, the law will prevail. Between equal equities, first in order of time shall prevail. That's also another equitable principle going to things like our recording statutes, race notice statutes, that kind of thing. Equity abhors a forfeiture, and equity will not aid a volunteer. So there's more of them. There's more maxims of equity, but there's a few of them for us to chew on. But this is it. This is like I haven't gotten into it yet, but here it is. Here is the difference between law and equity right here. The mere matter of locating the boundary of lands, however, doesn't involve the title. It's not a legal question. You got to understand, maybe I didn't, you probably already understand. The determination of a boundary is a 2-part question. There's got 2 parts to it. First question is the legal question. What is it? The second question is the factual question. Where is it? Now, the retracing surveyor has to ask and answer the legal question. It's lot 9 of Garfunkel subdivision. You can't go do the survey without asking the legal question and then answering the legal question as well. You can't drive down the street without knowing and applying the law of the roads. You can't do that. Everyone is charged with knowing the law, and not only knowing the law, applying the law. So all of that crap I heard during the first 15 to 20 years of my surveying profession is just that. It's crap. We don't just, that was covered. We don't know the law, we don't apply the law, we just deal with the facts. The fact is that deed says it's 100 feet wide and 150 feet deep. Now, damn it, go out there and put in 100 feet wide and 150 feet deep. That's all you need to deal with. That's actually a form of practice in the law, if you ask me. So I'm going to ignore where the real property is, and then I'm going to dictate a new position for the property. I'm dealing with the title at that point in time. I'm making title arguments at that point in time. That's practicing the law. But anyway, so the mere matter of locating boundaries of land has nothing to do, it's not a legal question at all. It has nothing to do with the title. It has something to do with the title. You can't go find the property without the title documents, but they aren't sacrosanct, especially the geometry in the deed. Is there anybody from Missouri on this?
I'm sure there's probably at least one. Somebody's got to be.
I don't want to come down too hard, but well, the first time I went to Missouri, and they were just about ready to hang me over this issue of breaking sections down, and and there's this other little thing. It's just a little thing. It's called the Constitution of the United States of America. Now, nobody gives a crap about it anymore. Nobody reads it anymore. But guess what it says in there? You can't have your rights adjudicated without due process of law. So how can surveyors go adjudicate people's property rights in their court? They can't do it. Even some of our fundamental principles of surveying, it's in evidence and procedures. Well, you got a shortage in the block. What you got to do is you got to prorate out that shortage and spread it out between across the block. That is the stupidest thing anybody has ever said on planet Earth. There's no freaking way you can go do that. A judge sitting on a bench can't go do that unless that judge has jurisdiction over every single lot owner and every single mortgage company before that could ever happen. And even then it will never happen. Why? Because our judges really, in final analysis, most of them, they don't want to upset the apple cart. That just creates more controversy. And they're elected officials. Why the hell do I want to, I don't want to rile up. I don't want to be in the newspaper over this thing. I need a way out of this. And that's where the expert surveyor comes in and helps them out. If the surveyor can do that. It relates only to the limit to which the land covered by the title extends. You see, when you do a proper retracement, you have identified the limits of the ownership to which the deed then expands or contracts and is covered by. So the deed, when justice is served, the deed, when there's a conflict, will always conform to what's on the ground. State versus Shaw. The object of the suit, therefore, is to ask. This is when Illinois had two courts. They had law courts and they had equity courts, and this was an equity case here. The object of the suit, therefore, is to ascertain the true boundary line between the contiguous estates, not to try the question of title on either side of the boundary. All that a survey does is to establish the line. It does not determine the title to the real estate. The object of a survey is not to try the question of title, because a survey isn't a title fight. Is not to try the question of title on either side of the line, but to mark the place of the old line where the property rights attached, where the ancient where the ancient monuments are found. And of course, a monument doesn't lose its status as controlling if its former location can be determined even through parole evidence. Similarly, a court of equity will not try title to land in a suit to establish boundaries. This question is a legal question. We have nothing to do with it. Was one for the courts of law, assisted as they are in respect to finding the facts by a jury. Law and equity do not undertake to do the same thing. They do not undertake to do the same thing. In equity, the object of the bill, the petition, the lawsuit, is to ascertain and fix the boundaries without reference to possession and without affecting the legal rights that either of the parties may have acquired. We think, however, that the court lost sight of the real purpose of such acts, which is simply to restore lost bounds. It may be asked, of what avail is this? What avail is it to do this if no conclusion follows as to the title or possession? But this question, this is a question with which we have nothing to do with, as it affects the wisdom of the law. As it affects the wisdom of the law. A lot of people can't wrap their brain around those concepts. So you're either, so you're the only judge and jury, the retracing surveyor, only judge and jury that most landowners will ever see. And why is that? You get hired as a surveyor to come out and retrace a boundary, and you come up with a determination, right, wrong, terrible, sublime. Even if they want to sue you, generally speaking, they can't. See, this is why we really have to take on this role of equity judge. This is really why, as surveyors, we have to take on this role, because the vast majority of surveying errors or poor surveying goes unchallenged. And probably the greatest challenge we have today in the land surveying profession is all the crappy work that has taken place over the last 60 years. Because actually, if you wait long enough, what was once wrong becomes right due to time, lapse of time, reliance into new monuments, and we have some really rigid so-called rules where, you know, we gotta go dig up that ancient boundary, that ancient monument, you know, dig until we finally find that ancient monument. What if nobody ever went into reliance on that ancient monument? We never talk about that when we talk about the ancient monuments. What if nobody ever went into reliance on that monument? And then that monument is a nothing burger because it never received what I like to call the blessing. It never received the blessing. The only reason a monument has any authority whatsoever, it is presumed to be imbued with the property rights of the landowners. Now, presumption, of course, is a fact, the legal fact until proven wrong. Most presumptions are rebuttable. Some aren't, but most are. But going in, the monuments are presumed to represent the true and correct property corners. And so you got the law on your side going in. I mean, if you accept the monuments, title documents don't actually match the monuments maybe, but you accept the title documents, then the legal fact going in is the monuments are the corners, the true and correct corners. And so if that's a legal fact going in, then whoever's going to challenge those monuments is going to have to overcome the presumption. They're going to have more and better evidence that the monuments actually aren't the corners. In the vast majority of cases, the surveyor is de facto judge and jury over the location of the property line between the adjoining landowners. This is Darrell Dean and John McIntyre, Establishment of Boundaries by Unwritten Methods, and the Land Surveyor. I think we dabbled in unwritten rights in that chapter 11 or 13, whichever one it was, in evidence and procedures. I'm not going to go down that rabbit hole. But the rights, in my opinion, are written. It's just an interpretation issue. Most of these decisions are never questioned. And if so, never go to court and become final. Dean and McIntyre, they were the professors at Purdue University back in the day. This little treatise doesn't even have a date on it, but the best I could figure out, it was, and talking to Gary Kent and some others, it was probably right around 1974 that it came out, and it was published for the ISPLS surveying publication series. Never go to court. Why do they never go to court? Because these aren't personal injury cases. Boundary dispute cases aren't personal injury cases. In personal injury cases, there will always be money for the litigation. In boundary dispute cases, there's no money for the litigation, generally speaking. Now, if you get sued by the title company, there's plenty of money for the litigation. Okay, so there is that. But average run of the day, run of the mill boundary disputes, the people are paying for the litigation out of pocket. And so there's the principles run high, but the war chest isn't necessarily there. And that's why you can be the worst surveyor, whatever state you want to say, you can be the worst surveyor in the state of Alabama, and every freaking property line you put on the ground goes through somebody's house, and you might not ever get sued. So what does that say about the land surveying profession? It's not good. But there's There's two primary policing mechanisms for all professions. One is board action. And if you've been around for 10 minutes, you know that the boards across the country, generally speaking, the boards across the country aren't going to do anything about a boundary line going through somebody's, kitchen. Okay. Oh, well, that's just the surveyor's opinion. They're not going to rule on professional judgment. There might be a board or two out there that might do it, but generally speaking, there is no board action in the land surveying profession. The medical profession, there will be board action. Legal profession, there will be board action. And the other is litigation. And they work well in the medical profession. They work well in with the clergy. They work pretty well with the attorneys as well, because there will always be money. There will always be insurance money. There will always be errors and omissions money. So that litigation will go forward, and the aberrant practitioners will either be run out of the profession or sued out of existence or severely disciplined. That doesn't happen in the land surveying profession. There are no consequences. There are no consequences for in those professions, the true professions, the clergy, the big three, the clergy, the medical profession, the legal profession. In those professions, results matter. In the land surveying profession, results by and large don't matter. It doesn't matter if you sent everybody to court, the equivalent of amputating the wrong leg. You sent everybody to court over nothing, over a nothing burger. I see the cases all the time. They went to court for no reason whatsoever, just that the surveyor didn't know what the surveyor was doing, by and large. And so, but in the medical profession, if you amputate the wrong leg, there will be consequences. So there's no consequences for the bad actors. Our boards aren't going to get rid of bad actors. The only way I see of salvaging the land surveying profession is we're going to have to do it from the grassroots level. And we got to take seriously this idea of being quasi-judicial officers. We are in the field making judgment decisions, and those will affect people's lives. And if we didn't do anything other than to take a lesson from our courts where these boundary disputes go, by and large, the result of those court cases, there are anomalies out there. Yes, there are, especially at the trial court level. But once you go to the trial court level and you go up on appeal, and then they have law clerks and they're doing legal research and the correct law comes to the surface, what ends up happening the vast majority of times is we're going back to the status quo, what was before, where everybody was happy, That's an equitable decision. That's an equitable decision. Surveyors therefore make final decisions in most boundary cases. In reality, these are final judicial decisions. See that? Judicial decisions. The only factor which makes them quasi-judicial is that they are subject to review and possibly changed by the courts. If that should be a big old fat capital bolded if. That is, the vast majority of them never go to court. Never go to court. The agrimensor is a judge. This goes all the way, supposedly, okay? Supposedly. I don't know if this Magnus Aurelius Cassidorius ever existed. The agrimensor is a judge. His only disciplines, certainly. Abandoned fields are his courthouse. He can seem fanatical if you watch him tramp over tortuous paths, looking for his evidence in thick woods and bramble patches. He doesn't use the common paths. Personal judgment shows him where to go. This is an investigator. This dude's an investigator. He explains his conclusion and tests his claims, deciding the litigant's boundary rights from his own travel. Like a mighty river, he takes land from some and gives fields to others. So trust us and appoint a surveyor. Once he's done with his work, the parties should be ashamed to litigate with straight faces, because the owner's titles for which one had to use professional expertise in the appropriate matters should not be in doubt. Z.A. Enos, Illinois, 1821 to 1907. This guy went to a Jesuit finishing school. I don't think they called them universities back then. And he came out and read the law in Springfield, Illinois, and he sat for the bar. If there was a bar examination, somehow or other, he actually became an attorney. There probably was some sort of examination, but he came out of school. He read the law with a practicing attorney, and then you were either given a law license or you took an examination. And but he found out when he became an attorney that he couldn't make any money practicing the law, because he was in Springfield, Illinois in the 1850s, and there was this guy there named Abraham Lincoln and another guy named Stephen Douglas, and they had all the work. So he decided he was going to do the next best thing and became a land surveyor. And he actually became pretty wealthy at developing land, doing land surveying. He never really practiced as an attorney much. And there's actually a park in Springfield, Illinois called Enos Park. He became a big landowner, became really wealthy. And he's the guy in 1903, shortly before his death, 4 years before his death, he was in possession of the Lincoln Letter. I don't know if y'all know what the Lincoln Letter was all about, but the Illinois surveyors had a conference just like everybody else was having. Okay, every couple of years they'd have a conference, and they were in 1856 when the new surveying manual for Illinois and Missouri came out. In the index was written to county surveyors the method for finding the center quarter. And so the government, the federal manual, the 1856 manual in the index, was telling county surveyors in Illinois and Missouri, you set the center quarter by running from the east quarter corner straight through the section, get a falling over here on the west quarter corner, correct for true, and then come back to the midpoint. That's where you set the center quarter. At the same time, Dr. Burke's solar compass was coming out, and he had in there, in his instructions, you set the center quarter by doing the line of the cross, the sign of the cross, which is what federal law actually says. And so there was a great controversy. And it was like it might have been their conference in 1856 or 57, and then 2 years later they had another conference. So at the first conference there was much heated discussion, can you imagine, over how to set the center quarter, and they couldn't come to a resolution. So what they got a committee of surveyors to go visit this young lawyer named Abraham Lincoln, who had been a practical surveyor. Okay, he had been a practical surveyor, and they asked him for an opinion. On how to set the center quarter. That's what's called the Lincoln Letter. And his opinion was federal law says you do the sign of the cross. It doesn't say how many times to do it. It says that's what you're supposed to do. And it doesn't talk about, well, what if it's already there? No, federal law says you do the sign of the cross. So he was actually he was interviewed in 1903, and he had the Lincoln Letter in his hand. So I don't think anybody knows where it is these days. So he wrote a little treatise called, do I not even have? It's called, The Early Surveyors and Surveying in Illinois. The surveyor in the field has no opportunity to consult authorities, counsel with others, or hold under advisements or subsequent adjudication. He must think and act for himself, and that quickly and firmly. In discharging his duty, he combines the threefold character of attorney, jury, and judge. At the 1905 Illinois annual report at the Illinois Society of Engineers and Land Surveyors in Chicago, there were a bunch of guys that came up and gave papers. That's what they did. There were no seminars. You wrote a paper and you presented your paper. So this is from some of those papers. A guy named W.D. Jones, Judicial Elements of Surveying, 1905. Surveying is something more than running straight lines and marking accurate measurements between known points. It is also that branch of engineering, I would say the law. No, not that as much a branch of engineering, but as a branch of the law. It is determining what the known points and what the controlling points of the survey are. A property line always is where it always was, in theory at least. If a property line is lost, it is not therefore necessarily the business of the surveyor to locate it where it should have been located, but rather to find where it was and therefore is. If the original monuments exist, they must of necessity be the best evidence. He's not only coming up with fundamental principles of retracement surveying, he's also identified our evidence criterion. Our evidence criteria. How much evidence do you need to gather? Well, you need to gather evidence and then you use the best thereof. Best available evidence is our retracement criteria. Best, you don't have to get, you're not going to get all the evidence you need. You need to gather and evaluate the standard of care, what all of the reasonably prudent practitioners would gather and evaluate under like or similar circumstances. That's the standard of care. The American standard of care and American jurisprudence. That's all you need. What all other reasonably prudent practitioners do in like or similar circumstances. Under American jurisprudence, American law, there is no requirement to dig down in the intersection and dig and dig and dig and dig and spend 3 weeks out there trying to find a sandstone monument. That's a burden we put on ourselves. Now, a lot of people don't like hearing that when I tell them that, but the standard of care doesn't say you got to go get a backhoe and dig up the intersection. What other reasonably prudent surveyor could do that? If your client wants you to do it, go do it. That's fine. It's a contract issue. You don't want to do it. You don't think you think it's beyond the pale. Terminate your contract and walk away. And I think that's one of the reasons why. Too many surveyors over the last 60 years have worked off of oral contracts, and because they're working off of oral contracts, my thought here is this is why we have such crappy work out there for the last 60 years, because when you're working under an oral contract without a termination clause and other clauses that you can lean on, then the tendency is going to be, well, I got to finish this survey. I got to finish this survey. I'm not going to dig up the intersection. I'm going to do a double proportionate measurement, drive a spike in the asphalt. It's probably not over the original monument down in the intersection. But that's what, that I think is a rich source of a lot of the crappy surveying that we're looking back on now, from the 60s, 70s, 80s, 90s. Best available evidence. Now, here's the thing. The reason we love our measurements so much is because we can check our measurements. We can check our measurements. We can get closures on our measurements. But just because you have precise measurements does not mean you have a correct survey. Just read the Alta standards, okay? They've made the distinction between precise measurements and correct results. How do you test your judgment? How do you know you got it right? Well, I believe there's a litmus test. And you got to know what the standard of care is. What other reasonably prudent practitioners do under like or similar circumstances. You go out and your evidence criterion, best available. You go out, you gather the best available evidence that all other reasonably prudent practitioners would use in like or similar circumstances. You weigh that evidence. Then you render a well-reasoned opinion on the location of the property lines. And if you can explain the boundary location doctrines that you are employing, and the Alta standards call them the appropriate boundary law principles. If you can explain what you did, then you have probably passed the litmus test. And that's the thing. A lot of surveyors, maybe we're losing them these days, but they can't explain what they did. They come into court, they can't explain what they did. They don't know why they put that corner where they put that corner. They don't know why they held that monument that they held, if they held a monument. They don't know why they broke the section down. Emerson, Coyle versus Butler, Washington State, 2012. Emerson couldn't explain why he didn't hold the monuments, and he actually pushed the boundary 32 feet to the east. He couldn't explain why he didn't hold the monuments. He had no reason. The math made him do it. So a lot of surveyors can't. That's one of the problems. They can't explain why they did what they did. This is still Jones generally conceded that most perplexing questions to surveyor arise where the original monuments have been lost. Lost section corners and quarter section corners is a case in and of itself. He must conduct a court case of his own. Well-defined old possession, equally jealously guarded by opposite interests, is good evidence when they're both happy with where that line is. The landowners, why would you go anywhere else? Why would you go anywhere else? He has done justice. S.S. Greeley, the surveyor, is for the moment a judge. At law, victory is often as disastrous as defeat. That is so true. You can go win in court, but guess what? In a boundary dispute case, you don't get your money back. I mean, there's a court-made rule, but generally speaking, you don't get your money back unless you have a contract, unless you have a statute, or unless the court-made rule applies, the common law rule on getting your money back. And it applies in a lot of instances in boundary dispute cases, and it's like this. If actor A, the next door neighbor, because of the activities of actors B and C, then your client and you, the surveyor, has to go into the court to defend himself and wins. This isn't universal. It's in many, many states, and you see it a lot of boundary dispute cases. Then he can recover damages and attorney's fees from actors B and C because they made him have to go to court to defend the title. But again, at law, victory is often as disastrous as defeat, because the only people who win in these cases are the attorneys, as we know. At the best, he has only laid down lines which will probably never be proven wrong. Mulford out of New York, his copyright's 1912, so he was practicing in the late 1800s, early 1900s. A large preponderance of the evidence, which point more or less clearly to one solution of the problem. He's an evidence gatherer. The fact that you've been willing to collect all data possible and hear all sides of a case begets confidence, and the rest is largely a matter. They don't call it the common law or common law courts because it makes common sense, but it does. It's common sense. And a lot of these, a lot of surveyors, there's not a whole lot of common sense going around. Okay, why in the world are you breaking that section down and moving that center quarter yet again? Where is it written? It doesn't even pass the common sense test. Once a section has been subdivided, why are we subdividing it all over again, especially in face of all of this occupation and the fences, and everybody's happy, and you're going to go in there and you're going to move the Dykes versus Arnold, Denison, you're going to move that center quarter 70 feet to the north and west? Really? And in that case, the court says it strains common sense. It strains common sense. Mulford was having conferences. He was gathering the people together. He was, they calls it being an arbiter in here somewhere, but what he was doing was mediating, and he was solving people's problems, which is another huge area of practice that we're not even tapping into, solving people's problems. I know John makes a living at it, but you know, John, you're an outlier. You know, that's not what happening all over the country. Okay, most surveyors are interested in starting controversies and solving. An expert in such matters. Judicial functions. Here it is, Hodgman, out of Michigan. Now he was probably 1913 copyright. He was probably sitting in that audience when Cooley was there in 1881, listening to it. Because judicial functions, where do you think he came up with that one from? Huh? Clark, Frank Emerson Clark. He wasn't a surveyor, which maybe most of you know. He was a title attorney. And he was approached by some people. Hey, you need to put together a book on surveying. And this was a treatise he did for the International Textbook Company, which was a chapter out of his 1939 second edition of Clark on Surveying and Boundaries. This is before it was, you know, adulterated by others, but an honorable, unprejudiced party seeking to find the true position regardless of consequences, and should act as a judge on a bench rather than a partisan employee. What kind of judge? An equity judge, not a law judge, an equity judge. The original surveyor is presumed to be absolutely correct. Why? Because the presumption under the law is the people walked the boundaries, blessed the monuments, went into reliance on the lines between those monuments, and then their property rights attached. That's why the monuments are so important. If they never received the blessing, it could just be a stick in the ground. Henry Sipe, as late as 1965, out of West Virginia. Henry Sipe, surveyor frequently helps settle boundary disputes by acting as a middleman, a mediator between the parties. Surveyor analyzes evidence and decides on basis of laws of surveys and court's decisions what weight to be given to each fact. Surveyor is supposed to make his survey in such a manner that a court will, this is Tilliston out of Montana. In this sense, the surveyor is actually a court. Even Williams and Onsred, 1986. Williams is a surveyor, but he's also an attorney. I think he had a practice in New York. Onsred, I believe, was a professor somewhere. And they wrote this for the American Bar Association, what every surveyor should know about, what every lawyer should know about title surveys. It was for the Real Property and Trust section of the American Bar Association, 1986. It was after a new edition of the Alta standards came out. Surveyors, having made an evaluation of the evidence, forms an opinion as to where he believes the lines will be located if fully adjudicated in a court of law. No, Williams, no, not a court of law, a court of equity. Typical modern day surveyor sees himself as an expert evaluator of evidence, if only so. He strives to arrive at the same opinion of boundary location, regardless of whether he's hired by his client or the client's next door neighbor. Hopefully that's true. Your duty as a land surveyor is to the people of the state, not to your client. The next door neighbor is a citizen of the state. The surveyor's opinion is founded on experience and applicable legal precedents. Yes. Unlike the attorney, the surveyor does not see himself primarily as an advocate for his client. No. Merely locating the lines described in a deed on the ground is not adequate for establishing the physical limits of property ownership. That's what they think we're doing. And that's what the people think we're doing. People know two things about land surveyors. We're the people standing on the side of the road, looking through that camera thingy, taking pictures with that camera thingy. And when we put the pink flag in around those rebar, we're showing them what they own. The resolution, and this is true, so true. I was talking about this earlier. The resolution of conflicts between the written and unwritten rights is one of the most difficult problems for both surveyors and lawyers. And surveyors and lawyers both, almost equally, I would say, don't understand the concept, don't understand what's going on. A well-reasoned, I put it, a well-reasoned opinion. A well-reasoned answer, a well-reasoned opinion. Even Brown recanted. In my early writings, I generally advocated surveyors should locate land boundaries in accordance with the written deed. All conveyances based on unwritten rights should be referred to attorneys for resolution. Within recent years, there have been cases, one in particular, and it was Western Title versus McCormick. Within recent years, there have been cases, one in particular, wherein surveyors have been held liable for failure to correct a change in ownership created by prolonged possession. Can a surveyor monument lines of ownership obtained by I hate this term, unwritten means? The means weren't unwritten. The case was a junior senior rights case. The case was a junior senior rights case. The west half of a short quarter section, 80 acres, was first sold out of a common grantor who owned the whole southwest quarter. Then the common grantor sold the east half, according to the government plat, to another landowner, and there was a 14-acre overlap between the government. You know, the government plat, on the government plat, even though you got a short quarter, they're going to give that first 80 acres the east 80 acres, they're putting all the slosh over here in the western boundary. This is in section 6. That first 80, they're going to have as many full quarters as quarters and quarters as they could get. So the plat showed 80 chains wide for that east half on the plat. He didn't sell it that way to the guy when he sold the west half. He sold the west half 80 acres. And that guy went into possession. That guy built a fence. That guy had it surveyed. And then McCormick came along, according to the government plat, jumped over the fence line 14 acres and drove in pins. The problem was the title company had insured, one title company had insured the guy who owns the west half 80 acres, and another one insured the property that McCormick surveyed, which was 80 acres according to the government plat. And they settled the boundary dispute, and then because the title companies had to pay out, it's especially McCormick, because McCormick's client's title company had to pay out, they turned around and sued him for $100,000. And Brown's teeth fell out of his head. Okay, he couldn't understand how in the world did his guy lose unwritten rights. No, they were written. There was a junior senior conveyance, and there was a junior conveyance from a common grantor who owned the whole southwest quarter. The GLO manual of instructions has no jurisdiction over private property rights. None. I don't know. I'm not going to get through this whole thing, Trent.
Yeah, you're fine. No,
I have diarrhea of the mouth. Let me I'll hit a few more and we'll see if we have any questions. Okay?
There you go. That's perfect.
All right. We already went over this. Title of property is a legal question. Location is a factual question. It's a two-part question. What constitutes a line is a matter of law. Where is it located is a matter of fact. A survey of a description doesn't determine title to land, but seeks to find the identity of the land embraced within the description. The only reason surveyors are licensed to protect the people of the state. Safeguard health, life, health, and property, and to promote public welfare. That's the whole reason we're like. This is the core issue. And at this core issue, we have more in common with the legal profession than we have with the engineering profession, because retracement surveying is not an engineering project. No matter what you hear, the only line that matters is the property line. And it is the ultimate issue in a boundary dispute case. Dowdell wanted to know the location of his property line. Jones told Gresham, you have 2 weeks to get a survey done to prove that you own the driveway. That's what surveyors do. They show people what they own. The purpose of this survey is to accurately locate the boundary between the plaintiff and the defendant's properties, not their deeds, their properties. Richardson claimed they owned the land. Not until Milam generated his opinion about the B to A fence did the Richardson, not until then, they never made a claim that they owned down to the B to A. It was on a diagram. Go point A, point B, until their surveyor said that they did. So rules of evidence, this was a sea change in evidence. In 1975, when the federal rules came out, they got rid of that old, we're not going to let experts come in and testify as to the ultimate issue in the case. Instead, they made a rule that says they can come in and testify as to the ultimate issue in the case. Everybody, 40, my unofficial count, I have about 42 states that have adopted the rules. It's no longer objectionable. So when Brown was telling us, just hide behind your client's deed and you don't need to give an opinion on anything, that's no longer any good. That's no longer any good. Because if you don't have an opinion on the ultimate issue in a boundary dispute case, one, they're not going to need you to testify. Two, maybe they will let you to testify just to get up there and make a fool out of yourself. Well, where's the boundary line, Mr. Keenan? Where's the boundary line between Brown and Smith? Well, I don't know. I just staked out the deed. Your Honor, we don't need this guy. He doesn't even have an opinion. We don't need him. And of course, there's Robillard. This is 7th edition. This is like circa 2011. He's still saying surveyors can't come into court and testify as to the ultimate issue in the case. North Carolina still retains that majority approach. See, it used to be before the rules, the majority opinion, in the majority of states, you couldn't come in and give an opinion on the ultimate issue. It was considered invasion of the province of the jury. In 2011, here we are. North Carolina still retains a majority approach. Really? 1986. Green High Wind Farm, North Carolina Court of Appeals, Rule 704. It's no longer objectionable. You will testify as to the ultimate issue in the case, or you won't testify at all. No witness can give an opinion on that. This is 5th edition. I still have, I never went to the 7th edition. I have the 6th edition. This is on page 509, 510. I think it pushes over to about page 530 something in the 6th edition. No witness can give opinion on the ultimate issue. When was the 6th edition come out? What, somewhere around 2000, something like that? He's still telling us you can't give an opinion. A Mississippi court ruled that the question of whether a surveyor can be asked, where's the true line? The court replied, this is not a matter about which they could give an opinion. He cites and Gitchner versus Antonio title 1969 Mississippi before the rules were ever adopted. This is inexplicable, but I digress. And Mississippi rules, not objectionable. Why we got rid of the ultimate issue rule? It was cumbersome. It would serve more injustice than justice. But in any rate, the testimony must be helpful or you were wasting our time. All right, and there's the loan detractor. Here it is, 5th edition, page 1. In keeping with recent legal descriptions, we have somewhat modified some of the terminology. Oh, Lord, they're modifying the terminology. For instance, seldom is the term property line or property boundary used. What? It's our belief that property rights, including property boundaries, are legal questions. This is it. This is that old, stupid, worn out misconception. And as such, are not addressed by land surveyors. Surveyors locate boundaries or land boundaries, or here it is. It's still in evidence. I bet it's on page 3 now, Trent, in your 7th edition. Surveyors survey deed lines. It's still there. Okay. Well, it's 7:30. We got any questions?
So, when is
Wanna take a
your,
breath?
yeah, I know, right? Exactly. When is your edition of evidence and procedures coming out? That's what I want to
Oh, Chucky's on it now, isn't he?
know.
Nettleman, is it Nettleman on it now?
Yeah. He's
Yeah,
working on it
all right.
now. That's the 7th edition one. So I didn't want to stop you earlier, but there was one in here earlier. How do you account for errors in deeds which were written before any of the corners were set in the ground? And then the next part of that is a legal description considered equitable if it calls out equitable items for its corner monumentation? So that was one earlier, but I didn't want to grab you on that. So
So
thoughts
you're
on that one?
gonna go out and survey a deed that has never been put on the ground? Is that what?
Yeah, how do you account for errors in a deed which were written before any corners were actually set in the ground?
Well, unless I'm working for a common grantor who owns all of the surrounding property, more than likely the boundary lines on all sides have already been established. So you got 2 choices. Let's just say it's a rectangle. You got a road right away out front. Well, you're not going to encroach on the road, so I can't do that. Then the boundary lines on your east, west, and north sides, the roads on the south, your boundary lines on the east, west, and north sides are all established boundaries. And your deed in the middle there doesn't join up with those. You got 2 choices. Go jump the fences and drive in new pins and start the lawsuit, or basically accept what's there. I mean, I don't know what else to say.
Yeah, no worries. Okay. And then that same one was is a legal description considered equitable if it calls out equitable items, meaning the corner monumentation? So
Yeah, I would say so. Yeah.
Perfect.
Call for monuments.
There you go. Yep.
Called for and uncalled for monuments still have a little bit of a checkered reputation. I think I've seen an Indiana case where the judge said, trial court judge, it wasn't the appellate courts, where the judge said, well, I'm not accepting any monuments that aren't called for in the deed, although, that shouldn't be a hard and fast rule.
Here's one. Should we be calling them legal descriptions on our surveys?
I don't have any problem with that. There's been that discussion in the past. I've kind of gotten away from calling them legal descriptions, just call it, matter of fact, I'm so far away from it, I just call it the deed.
Yeah, this one says, as survey descriptions. Rob chimed in, land description. So yeah, I know that that word legal descriptions has been probably the last 10 years has kind of come up about using it or not using it.
Yeah. I don't have a big problem with it. We do certifications on our survey, and everybody knows that that's not a guarantee or a warranty.
Yeah. Garrett, I like the idea that we should be able to determine unwritten rights, but I don't feel comfortable doing it. So because of all the material saying that it's unlicensed practice of law. So,
well, see, there's the misconception. Utilizing the boundary location doctrines to solve the question of location. Adverse possession, this is what I came up with as an exhaustive list. Adverse possession is the only one that's both a title doctrine and a location doctrine. All of these others do not affect the title, just as we saw in State versus Shaw. They don't affect the title. It's not the practice of the law. Determining a factual situation when there's no legal question, how can you be practicing the law? And that's the charge that, you know, you hear is, well, you're telling people to practice the law. No, I'm not telling people to practice the law. Again, equity judge. An equity judge cannot dispense the law. An equity judge can only bring in factual situations and make an equitable decision. These are all equitable decisions.
Yep.
And I ran across, doing my latest newsletter, I ran across another one. I've got one more to put on here. Then I'll think it'll be exhaustive, and that's the strip and gore doctrine, which is basically a location doctrine. Strip and gore, you're not making a legal decision there. Strip and gore. What's strip and gore? It can be a common grantor situation, or it can be a landowner conveying what that landowner trying to convey the rest of his or her property up against another adjoiner, and they leave a gore, a strip, usually, you know, kind of small. So the presumption under the law is that was conveyed as well. That's the presumption that it lands, and that's not a legal question. That's a legal fact. Presumptions are legal facts. When you see the word presumption in a case, they're talking about a legal fact until somebody proves it wrong.
Gotcha. John, you want to add anything tonight? I know we were talking about when we finished up evidence and procedures a week or two ago, we talked about doing a whole section on Cooley because of the appendix, but I'm sure we could add more to this. Yeah, John?
Yeah, there were some comments here about
Yeah.
writing as survey descriptions and you know, how to rewrite it, how to write the description of the deed. And actually, there's this doctrine called the doctrine of reformation that is a very, very strict doctrine that gives only certain limited conditions under which a new description can be, an existing description can be replaced by a new one. It requires the original parties or someone in close proximity to those original parties who knew what the original agreement was to be able to correct the language in the deed to conform to the original agreement when the deed has a mistake or an error. And that can only be applied in that kind of a situation. So even a judge can't rewrite a deed. They can't, you can't just write a new description and then insert it in the chain of title. It blows the whole thing, chain of title apart, because now you're throwing boundary location data into a title record and crisscrossing that boundary between what Jeff's talking about here, the law of title being the law, where the location being the equitable decision. So even your ALTA requirements, the ALTA standards say don't write a new legal description, only in certain limited conditions. And that's usually when there's a merger of parcels, more than one parcel on your survey, you're going to do an overall composite description, of course. Or you've got a parent parcel, you're only selling part of it. Well, yeah, of course, you got to write a description of the portion you're surveying. But those are about the only times we get to write a new description and that's because they're basically new parcels, new composite or new pieces being sold. So that's the only comment I think I'd have.
Yeah.
Other than that, great job, Jeff.
Yeah, exactly. That's awesome.
Thanks, appreciate it.
George shows up every Monday, but he said great perspective for many of us that should have been more aware of this using decades ago. So George, that's why George chimes in and gives his stories every week for all of us. So I love it. But it's getting late for you, and I always appreciate your time and jumping on here. Anybody have one last question, one burning question before we let Jeff go? If not, we'll let you go have your maker's mark.
I had a great time.
As always, thank you. I appreciate it.
All right, I'll have a good evening.
Thanks, Jeff. Have a good night. Bye, guys.